SJC-12544, June Stearns and Clifford Oliver, co-executives of the estate of Wayne Oliver v. Metropolitan Life Insurance Company, and others.
Good morning.
Mr. Heller, good morning.
May it please the court. I'm John Heller. I'm here on behalf of General Electric Company. The statute of repose is a model of clarity. And if it's applied as it is written, it is very simple in its effect. As this court has noted, it creates an absolute bar after 6 years to tort claims against certain participants in the construction industry. The key wording of the statute for our purposes here today is the language that says, in no event shall such actions be commenced more than 6 years after the earlier of either the opening of an improvement to real property or the substantial completion and the taking possession by the owner of the real property. So that's the language the legislature used to signify that after 6 years, we, the legislature, want there to be an absolute bar to tort claims against the designated participants in the construction industry. What you're being asked to decide by the district court's certified question is whether the words "in no event" really mean in some events. If there are some circumstances, as specified in the court's question, under which tort claims can be brought against participants in the construction industry, not just more than 6 years after the improvement is completed, but in this case, almost 50 years after the completion of the improvement. And we submit that the clarity of that language is such that it admits of no such exceptions. As you have said repeatedly in your cases, the first place you look to determine legislative intent is the language of the statute itself.
What about Klein versus Cataldo, which is, at least in dicta, suggesting that if there is control, the statute of repose doesn't apply?
Well, I think it's important, Your Honor, to remember how the word control was used in Klein, and it was also used in Dighton, a subsequent case, in the same fashion. This court set out to explain why there was no equal protection violation when different time limits were set by the legislature for two categories of persons. The first category being those involved in the construction industry. The second category being those who had a possessory interest in the improvement to real property after construction was completed. And you used the words lessor, tenant, owner, and then you threw in a catch-all phrase, others in possession or control, out of an abundance of caution, I suppose, because there could be others who weren't owners, tenants, lessors, but who nevertheless had a sufficient possessory interest in the property that they were in control of it. But you never suggested, in any case, that control was an element that might take away the protection of those whom the legislature clearly intended to protect, that is, those who were actually in the process of building the improvement to real property. So I think that's the answer to the question, is that control really is not at all an element of the statute of repose, but instead it's a descriptive term that this court used in an effort to explain who the second category of persons were that were outside the scope of the statute of repose.
So pragmatically, if you are right, the consequence is that an individual who has suffered from asbestos exposure may bring a claim against the manufacturer, but not against anybody who arguably was negligent in the construction of any improvement to real property where he was negligently exposed to asbestos.
After 6 years, yes.
Well, I mean, face facts. Do you agree that that means that persons who suffer from asbestos because of the long latency period will never, or almost never, be able to bring a claim against anybody involved in construction negligence?
If you assume, as the district court did, that there is this long latency period, and certainly that's generally acknowledged to be the case, although I don't believe there's ever been a definitive study that breaks it down, but if you assume that to be the case, then what I would say in answer to your question is that is exactly the result that the legislature intended. As this court has explained repeatedly, the intention of the legislature was to create an absolute bar to tort claims against those persons involved in the construction industry after 6 years.
And in fact, that point is where you would say we found agreement in the dissent and the majority in Bridgewood?
Oh, absolutely. If anything, I would say the language in the dissent was even stronger on that point than the language in the majority opinion in Bridgewood. That was some of the strongest language that I've ever seen, and I've represented GE in these cases all over the United States for the last 25 years, some of the strongest language I've ever seen in support of a statute of repose.
Can I ask about the amendment to the statute that's discussed in the Commonwealth versus Owings Corning case? So did the Commonwealth give itself a special out from the statute of repose? Is that what happened in the 1986 statute, the asbestos revival statute?
Your Honor, that's my understanding, that the legislature, which by that time in 1986, 32 years ago, was very well aware of all of the problems with asbestos that are being discussed in the context of this case. Being very well aware of those problems, what the legislature did was it set out, having studied the issue, and having studied the costs incurred by public bodies that were removing asbestos at that time from public buildings, the legislature decided, as it was entitled to do, to revive claims for asbestos removal costs by public bodies for a limited period. I believe the period was 4 years, if I'm not mistaken, from the date the asbestos revival statute was enacted in '86 until I think it was July 1st of 1990, if I'm not mistaken.
So they essentially got rid of the statute of repose for themselves for 4 years?
Yes, that's my interpretation of what happened.
And your argument then is the Commonwealth, the legislature had an ability to open this up for others, and it didn't. Just basically gave itself the benefit of this.
That is our position, yes, Your Honor.
And it still maintains that ability.
It could do that again. It could do that again very readily in the context that brings us here today. It could create an exception for bodily injury claims based upon asbestos exposure. And in fact, as we point out in our brief, many states have done that very thing. And as this court's cases make clear, you believe in the separation of powers. And you understand that if something of that nature is to be done, if there is to be an asbestos exception, it's the job of the legislature, the people's elected representatives, to do that. And as I started to say, that is how it has been done in many states across the Union, including right next door in Connecticut. And we cite the Connecticut statute in our brief, as well as a number of other statutes. I personally observed it in my home state of Illinois, where we had a statute very similar to the one here in Massachusetts for decades, and asbestos cases were barred by the Illinois statute of repose for decades, and the legislature finally was persuaded through the normal political process to create an exception, and that's what they did. I believe it was 3 years ago now.
So is that how you explain the Harder case in Iowa?
No, Harder didn't involve an exception to the statute of repose. What I believe Harder stands for is that steam turbines, which are the devices we're concerned with in this case, as well as the insulation systems that are used on those devices so that they can operate properly, those are improvements to real property. And of course, that's been held by courts all over the country. In our brief, we cite, I believe, a selection of 3 or 4 such cases, reported cases, that reach that same conclusion. In other words, that steam turbines, including their insulation components, thermal insulation, are improvements to real property. There are many, many additional cases, unreported cases from the trial court level all over the country that we didn't cite in our brief because we didn't think they really added anything. They reached the same conclusion as the reported decisions that we did cite. But we could supply probably another dozen or 15 such unreported cases. they don't get appealed for the most part. It's pretty rare that a plaintiff who has lost on that issue at the trial court level wants to, especially in a state where there's no appellate decisions on point, they don't want to create bad law, and they know that they're going to lose on that issue, more likely than not, if they take it up on appeal, and so they don't do it. I had a case like that in Ohio just last year. We won on the statute of repose at the trial court level. There were, in fact, 2 different trial courts in the state that had come out with opposing opinions on that subject, and nobody among the plaintiffs' bar wanted to rock the boat and risk getting an adverse appellate decision, which would then control statewide. Mm-hmm. So I can give you every assurance that that's an issue that is well settled in the law, that steam turbines and their insulation are improvements to real property. And in fact,
the plaintiff has, I guess, a creative argument, might even be their last one, that since the cutting of the asbestos is what caused the injury, that we're not really dealing with an improvement to real property. I wonder if that argument has been successful anywhere.
There have been a small handful of cases that have accepted that, and they're cited by the plaintiffs in their brief. As I've read those cases, and I've read them many, many times over the years, because this is an argument we see every once in a while, my conclusion is that those cases focus more on the improvement. They say, this is what we're interested in, is the nature of the improvement. And we're going to take the position that until the improvement is completed, all the parts are attached and it's fully assembled, it's not really an improvement, and therefore it's outside the statute of repose. The statute here, though, is very, very different. The statute here focuses on the conduct of the persons involved in the construction process, starting with design, planning, things that are done before anyone ever sticks a shovel in the ground, and then continuing all the way until the improvement is completed. And in some cases, there's a case, I believe it's a Coca-Cola case, it talks about engineers who, after the improvement, in that case it was a water treatment plant, was opened up for business, the engineers remained on site for 5 years trying to correct various problems. And yet, that post-construction conduct was held by the appeals court in that case to be covered by the statute of repose under the rubric of general administration of an improvement.
But we're not, we're here on a reported question. So the issue of whether it's an improvement to real property is not before us.
I understand that.
So if you're asking us to essentially answer the question, yes, it can. Yes, the statute of repose can, if the judge makes the findings of fact necessary for it to fall within its rubric, it may bar it. But the issue of whether this was an improvement to property or not, I think would rest with Judge Zobel, would it not?
I completely agree, Your Honor. That's not part of the certified question. Nevertheless, it was in response to a question by...
I understand.
Can I ask about the control issue? I understand your way of interpreting Klein. My question is just factually. I don't know if it makes... The asbestos exposure is when they were building the building, right? There's no suggestion that the exposure to the dust occurred during this post-construction period, right?
No, he was long gone. He had departed the site many years before any of that work took place. So our opening shot in response to that is it's totally irrelevant for that reason alone. Right. It had nothing to do with Mr. Oliver. We also say that the work we did post-construction involved a relative handful of episodes where our service people were contracted to come out and assist with certain maintenance activities. There's not a scintilla of evidence anywhere in the record that suggests that on those occasions the GE service engineers had control over anything whatsoever.
Of course, going back to the Chief's point a moment ago, dealing with my question, the issue of control, again, the factual issue of control is not before us.
Well, it's In a sense, I think it is. It's built into the certified question. But I'd simply add this. When you think about the facts in this case as found by the district court in her opinion, it's important to put them in context. This was a denial of a motion for summary judgment. So all of the findings, except when they're based on admitted facts, all of the findings are interlocutory in nature. If this case ends up on trial back in the district court, we fully are entitled to try the issue of control. And as the district court pointed out, I think twice in her decision, federal summary judgment procedure mandates that she view all of the facts in the light most favorable to the plaintiffs and that she draw all reasonable inferences in favor of the plaintiffs. So her findings are not at all like those that you would have based on a final judgment after a full trial.
All right, thank you.
Thank you.
Mr. McCann.
Thank you, Your Honors, and may it please the Court, Michael McCann on behalf of the estate of Wayne Oliver. The certified question that the district court presents today raises a few distinct issues. I want to first start by talking about the issue of control. In Klein, this court found that there was a valid distinction between those contractors who completed their work at a job, handed control of the improvement back to the premises owner, and then later on, a incident causing injury occurred.
Well, they didn't really do that. They drew a distinction, right, between builders and others like tenants, landowners, and others who retain control, right? They didn't draw a distinction between two different types of builders, right?
They drew a distinction, and they used the terms contractors versus owners, tenants in possession and control. But you have to look at that quote from the Burmaster case where the court really decides where that distinction lies. The court found that that distinction lies in the ability to prevent that injury-causing incident from occurring. And that all comes down to who has control of the improvement at the time of the incident. Those contractors who are long gone.
Again, you know, they're doing it in the context of distinguishing suppliers, right, from builders. It's a bit of a digression anyway, right?
Respectfully, I think that that paragraph deals just with the issue of being in control at the improvement at the time of the incident. There's a separate discussion that talks about the difference between builders and suppliers. That's not really relevant here. The court, in that one quote from Burmaster, talks about the distinction between preventing and being able to directly prevent the incident from occurring. And it found that when you're no longer in control, it's very, very difficult to prevent that injury-causing incident from occurring. But those who have control at the time of the incident can directly prevent the harm from occurring.
But aren't they referring back to Justice Kafka's point about owners and tenants? I mean, there's a limiting phrase in that discussion.
They use those terms, owners, tenants, but like I said, the distinction that they find, if you read that quote from Burmaster, it's not about being an owner, it's not about being a contractor, it's about being able to prevent the incident from occurring. Those who are in control are in the best position to prevent that incident from occurring. And that's where the distinction was found, and that's why they said it's owners, tenants, and others in possession or control who don't receive statute of repose protection.
But isn't that in the context of the constitutional arguments that were made?
It is. It was in the context of a equal protection argument, but I think it certainly is dicta, but that's certainly the reasoning led to the holding that held that those who are in possession or control do not receive statute of repose protection. So yes, it is in the context of a equal protection challenge, but I think, you know, it could have been just as easy for the court to say, you know what, the statute applies the same to everyone. We don't even have to go into this discussion about equal protection. But instead, they made the specific distinction between those in control and those not. So it was certainly important to the court's holding in Klein in that case.
What about the Coca-Cola bottling company of Cape Cod case?
Yeah, that deals with, you know, control after the incident giving rise to the cause of action. I think the real important issue here is control at the time of the incident giving rise to the cause of action, which is what GE had here when they were in control of construction of their products. Coca-Cola deals with control after the fact. And yes, GE did have control, and that's certainly a fact up for debate here. But what really matters is the control that they had at the time of the incident.
But
giving rise to the cause of
every contractor and architect has control of the building at the time of the construction.
They do, but not at the time of the incident giving rise to the cause of action.
So aren't you going to gut the entire statute of repose by doing that?
Nope, because Your Honor, respectfully, no, because you're right, in a typical statute of repose case, like Bridgewood, the contractor comes in, does their electrical work at the job site, finishes the work, and then is long gone when the incident happens. The difference here is that GE had control at the time of the incident. Yes, every contractor that comes in has control.
But let me just press you. The incident occurs during the construction. The cutting of the asbestos happens during the construction period. It doesn't happen during the subsequent period, the 20-year later.
Exactly. So that's the difference between GE having control of the improvement at the time of the incident versus Bridgewood. That contractor's long gone when that fire occurs. They are not in control at the time of the incident. So that's the distinction in control.
In Bridgewood, wouldn't the analogy be that the installation of the defective electrical material was the incident, much like the cutting of the?
That's the negligence.
That's
the negligence. The incident is the fire. The incident in Klein is the shattering of the glass that causes the plaintiff's injury. There's a difference between the negligence and the incident. It just so happens here that they kind of combine at the same time.
They become the same thing in this case?
No, I don't think they're the same thing. The negligence here is the decision to use asbestos and the failure to warn about its hazards. The incident is the cutting and the releasing and the inhaling of the asbestos fibers. So they're more close in time, which shows that GE had control and could directly have prevented this incident from occurring.
But isn't that simply a different way to characterize the negligence? You could say they were negligent in the cutting.
You could say that, and they were negligent in the cutting, they were negligent in the specification of asbestos, and they were negligent in the failure to warn about the hazards that were being encountered. So there's a lot of negligence that happens here, I believe, and it all happens, and this is but the incident is the actual release of the fibers and the inhalation of those fibers. That's what causes Mr. Oliver's injury.
Can I ask about the 1986 statute, where the Commonwealth seems to give itself a break, but it doesn't deal with anyone else? Is your understanding that that statute also gutted the statute of repose?
No, Your Honor, respectfully, I don't believe that that statute gives the Commonwealth a special out, as you termed it.
Yeah, what is your understanding of what it does?
My understanding is that at that point, these asbestos personal injury claims were not considered construction statute of repose type of claims. They're considered products liability claims. And in Massachusetts, we don't have a products liability statute of repose. So it would be and by creating that revival statute, there was no intent to actually deprive the asbestos personal injury victims of their claim.
I'm confused.
Well, why would it have been necessary then to make the exception at all?
Because there still would be property, like this exception was for property damage claims. So they needed an exception to make sure that these contractors and those individuals who used asbestos would be held liable for property damage claims. If anything, it certainly doesn't show that there was an intent to deprive the personal injury victims.
I'm confused. So a product liability, why would it not be the same analysis of a product that causes damage to property? I'm confused by that.
It's just that these personal injury claims were not considered and had never been considered to fall under that statute of repose.
No, but forget about your claims for a second. Why would the Commonwealth have needed to do this in 1986 if they didn't need to get rid of the statute of repose?
Well, these weren't product liability claims. These were claims arising from the negligent construction of these buildings that caused property damage.
But that's what these claims are too, negligent construction causing personal injury as opposed to negligent construction causing property damage. I'm confused why that's different.
And there's products liability claims involved here too with the products that GE had installed and specified here too. So I think that's where the difference lies in that statute.
I'm sorry, so you're saying there are separate product liability claims?
Well, these are products that GE has specified and installed here, as compared to just the property damage claims that would be revived by that statute.
Right, but you know what a product liability claim is, and are you contending that this is a product liability claim or a negligent construction claim?
It's difficult to say. I think there's a little bit of both here because there is products involved. These are steam turbine generators. They're products that are being installed by GE. They're not constructing a building. They're actually products, and the asbestos products that Mr. Oliver was exposed to are installation products. They're not.
But product
construction
liability is
process.
generally targeted against the manufacturer or seller of those products.
Sure.
Was GE a manufacturer or seller of these products? And if so, why didn't you simply bring it as a product liability matter?
It is brought in a negligence sense, and GE is a manufacturer of the steam turbine generators, and they sold the steam turbine generators to Pilgrim and to Calvert Cliffs and those entities that installed them. So there is a product involved here too. But I think, I think it's important to look at the intent of this statute and ask whether this statute was intended to create absolute immunity. I think either way, whether you look at it that way or not, the result here, if this statute applies to asbestos cases, is absolute immunity for those who incorporated asbestos.
So
into
that's obviously a huge issue. What happens with latent disease? And going back to GE's first point, well, the statute says what it says. If there's going to be that type of immunity that exists or doesn't exist, we really need to see it in the statute, don't we?
Well, you have to look at, the court has to interpret the statute. And in the way the court should interpret.
Only if the plain language doesn't answer the question. I mean, you have to interpret ambiguity.
Well, you have to interpret the plain language in the context of the problem that the legislature was trying to solve and the object that they were trying to accomplish. And the problem that they were trying to solve was the threat of unlimited liability for these contractors. And you have to look at what they did to solve that. Did they go back to the old rule of absolute immunity? No, they chose a statute that would allow time for the vast majority of claims to accrue. So it's clear that their intention was not to go back to that old common law rule of absolute immunity for contractors after they finish their work. So you have to look at that, and then you have to also get beyond the plain language here too, because the plain language and a plain read would lead to the absolute absurd result of absolute immunity for those contractors who incorporate asbestos into improvements and exposed workers in this Commonwealth to known carcinogens. Giving those actors and those entities who took such deplorable decisions to expose hardworking people in this Commonwealth to asbestos, that's not a reasonable result.
That sounds like a tremendous public policy argument.
I mean, in this situation, that's how the district court saw it too. And this result, I think it's beyond just a public policy argument. I think it's also a look at the intent of the statute argument. And the intent of the statute was not to grant absolute immunity. And I think it's not just a fairness argument. This is an argument that this statute, if it's applied here, it violates the intent. You have to look at whether the legislature intended to grant absolute immunity to those who are involved in exposing people to asbestos and putting asbestos into improvements to real property. And everything from the legislative history says that that's not what they were trying to do.
Well, I mean, the bill was passed in 1968. At that time, were we aware of the dangers of asbestos?
People were aware of it, but not in a litigation sense.
Okay, so there's no reason to think that the legislature was contemplating or thinking about the latency period of asbestos when they enacted this statute.
They absolutely were not. And you can look at, and that's shown by the Senate report. And the table in the Senate report, which lists out the percentage of claims that we filed each consecutive year after work is completed. After 14 years, they say that 100% of all claims will be accrued and filed against these contractors. Well, in an asbestos case, you can't have a claim within 14 years. All of the claims are going to be accrued and filed after 14 years. So we know they didn't consider asbestos claims when the statute was enacted in 1968.
But there's a difference between an unintended consequence, which the legislature, through its plain language, has required, versus an intent to exclude a category of claims from a statute. You're still stuck with the in no event language of the statute of repose.
And this court has found other circumstances where the in no event language didn't matter. In Klein, statute was held that it doesn't apply to material men, owners, tenants, and others in possession and control. In Dighton, is found that it doesn't apply to suppliers of standardized products. and it's found that it doesn't apply to those who do not perform acts of individual expertise or provide particular services for the design and construction of
Because
particular
you're
improvements.
citing cases where the cause of action didn't go forward because of the statute of repose.
Well, Dighton is a little different because they wanted the plaintiff in that case, or was a third-party defendant, wanted to bring someone in. But the court still looked beyond just the plain language of the statute and found exceptions. So this fallacy that there is no exceptions and the plain language has always been applied in the statute, it's just wrong. And you look at the Sisson case.
Well, you got to, I mean, going back to Justice Budd's point, though, you have to recognize that Klein was a discussion in the context of the Equal Protection Clause.
Absolutely. That's certainly what it was, but considering what the facts are in this case and what that analysis says, an application of the statute to someone who is in possession of control at the time of the incident giving rise to the cause of action would go completely against what that reasoning was in Klein under the equal protection analysis. So that would still violate that. And I want to make a point on due process. Now, this statute was challenged based on due process in Klein, and the court found that it did not violate due process. But when it did that, it left open the door for a due process challenge under particular circumstances. And in that footnote that I've cited in my papers, the court said that a statute which shifts most of the risk of loss away from members of a particular industry and onto the general public may be a violation of due process because it doesn't serve a legitimate public purpose. That's exactly what we have here. We actually have it worse, because it's not just most of the risk of loss that's being shifted away from those who incorporate asbestos into improvements. It's all of the risk of loss, because like I said, the statute would grant absolute immunity. And that serves no public purpose.
So I'm just trying to say, are you arguing that the statute of repose is unconstitutional?
If applied to asbestos-related personal injury claims, it violates due process.
Because it has no rational basis?
It doesn't serve a legitimate public purpose. And really what the crux...
Is that different from no rational basis?
It's a good question. It would seem to be the same thing. But really what the crux of it is that when the statute doesn't allow time for the most meritorious claims to accrue, that's when it violates due process. And in the Senate report for this statute, they actually considered that. And when they were looking at the reasonableness of the limitations period that they were going to enact, they said, the court will not inquire into the wisdom of the legislative decision in establishing the period of legal bar, unless the time allowed is manifestly so insufficient that the statute becomes a denial of justice. That's exactly what we have here. A 6-year repose period for asbestos personal injury claims is manifestly insufficient because a claim cannot arise in that 6-year repose period. That leads to a denial of justice, and that's a violation of due process.
If I can ask you a more fundamental question. We have had thousands, tens of thousands of asbestos cases in Massachusetts. This issue has only reached us today. Does that mean that all the other cases have been brought on a product liability theory?
It means that it's only been until very recent times where these asbestos defendants have changed their defense in a way and have started raising this issue under the construction statute of repose. Like I said, these claims were always considered to be product liability claims. And that's why the statute of repose in the construction context just hasn't been raised until recently.
Okay, and do we have, as part of the record, the complaint in this case?
Yes, it is.
And is there a difference between they were negligent in the construction of the nuclear reactor because they permitted asbestos to be cut in a manner in which it would expose those who were involved in the cutting or near the cutting to asbestosis, versus they have created a negligent product, to wit, a reactor which contains asbestos, and that makes it a defective product? Which claim have you made?
Your Honor, I've looked at a lot of things in preparation for today. The complaint is not one of the ones I've looked at recently. So if I could take a look at that, and I can write you a 16L note.
But I gather your position is, regardless of what we do with regard to negligent construction, it would not affect a claim that a product is defective because it contains asbestos.
True.
So with that point, given that you can sue on the product, does that mean that the statute of repose does have a rational basis, because the plaintiff is not deprived of any remedy, the plaintiff is deprived of a particular remedy. So that the plaintiff retains the product liability suit against the manufacturer of the asbestos, but there's a statute of repose in place for these types of construction problems. I mean, that makes it harder for it to be unconstitutional, doesn't it?
If there is a products claim involved in the same situation, I think there are going to be situations where it isn't a product, where it could just be a plain negligent construction of a building, and that would be a different situation.
Right, but I take it that in every asbestos claim, you may bring a product liability claim because the product itself is constructed in a way that, I take it you have to cut this asbestos to put it in, right?
Yes.
So the people who built it who manufactured it knew it would have to be cut up.
Absolutely.
Okay, it's complicated.
Okay, thank you.
Thank you.